Well, it's 12 o'clock, and I guess it's time to start our webinar today. Hello, everyone, and welcome to the East-West Forum, arranged by the Stockholm Arbitration Institute, the SCC. I'm Natalia Petrik, legal counsel at the SCC. Let me begin by saying a few words about this event and how the program will be organized. This event has two purposes. The first one is to give an idea about arbitral laws and practices in 5 post-Soviet countries: Russia, Ukraine, Kazakhstan, Azerbaijan, and Georgia. And the common denominator for parties from these countries is the tradition to resolve their trade and investment disputes in a third neutral forum. Most often it's in Stockholm. And in fact, 1/3 of the SCC international caseload has connection to East-West trade involving a party from one of these countries. And the second purpose is to start a dialogue about international arbitration as a field for professional development. Over the past 5 years, the SCC cases generated more than 1,200 arbitral appointments, and thousands of lawyers participated as representatives of the parties, many of them coming from the countries which are in the focus of today's event. So we hope that this forum will become a platform for networking and knowledge sharing. This webinar will consist of a keynote address, a panel discussion, and a live interview in the end. And we encourage the audience to participate and to put your questions via Q&A function. This webinar is being recorded, and the recording will be made available on Vimeo. So let's start. Dmitry Yevseev, who is a US qualified attorney based in London, a partner of Arnold and Porter law firm and the vice chair of the SCC board of directors, will speak about the art of persuasion in arbitration advocacy. Dmitry, the floor is yours.
Thank you, Natalia, and thank you all of you for joining today. It is my great pleasure to talk to you today about persuasive advocacy. And I have 15 minutes for this presentation. But studies say that I really only have about 15 seconds before some of you tune out or start multitasking. And this is just like a hearing. You may have an hour for your argument, but you could lose your arbitrator's attention in seconds if you don't make your presentation worth their time. So to make this like an arbitration hearing, I do have a PowerPoint slide deck. It has only 3 slides. And that brings me to the first of the 3 slides. And let me see. Okay, here we go. So the first slide is know your audience. Now, I love this cartoon. As arbitration counsel, you may have a lot to say, but an arbitrator is only interested in things that will help them decide their case. So if you drown an arbitrator in information, it is not helpful to your client or to the arbitrator. You want to focus on key issues and provide just the right level of detail for the arbitrator to follow along. Arbitrators don't like it when they feel like counsel is wasting their time by telling them things they already know, by talking in generalities, or spending time on minutia that don't matter. So keeping submissions concise and avoiding petty squabbles with the opposing side is almost certain to help you make your case with any tribunal. Also, it helps if you show energy and make good use of visual aids, as so much of the information we take in is nonverbal. I remember several cases in which a well-made demonstrative was critical to winning the case. In one case, the tribunal even took what was a very simple demonstrative and copy-pasted it into the award, even though it was prepared essentially the night before the argument to rebut a point that was made by the other side. Now, Of course, you also want to use any information that you have about particular arbitrators. What issues are they likely to be interested in? What kinds of arguments are likely to be appealing to them? And what style of presentation will be most effective with them? Arbitration advocacy can be more art than science because you're ultimately performing for an audience. This brings me to the second part of my remarks, which is about knowing your case. Like Michelangelo, you start with your block of marble, facts and legal issues, and you get to know this block really well. And then you start to sculpt your case. Now, good advocacy always starts with getting to know the evidence and making sure that the case you present is consistent with all the evidence. So you cannot just sweep away the bits that you don't like. You have to build your story around them. Now, I'm a believer in what one of my professors at Harvard called a core theory of the case. A core theory is like your overall theme or a distilled explanation of why a tribunal should rule for your client. And a good core theory works with every main element of the case, and everything you argue ideally should tie in back to this theory. It's hard to give an example because a core theory is developed with the very specific facts of the case in mind. But even if you have several defenses, say to a breach of contract claim, and some of these defenses are very technical, and some of them depend on a literal reading, and some of the arguments are more common sense commercial agreement arguments about common sense parties' conduct, you may still be able to tie all those arguments together in one core theory. You might be able to argue that it was essential for all the parties to be able to rely on the literal wording in order to provide this certainty in commercial dealings, and that your party, your client was harmed by the other side's conduct or vice versa. You were not, the other side's arguments are not valid for that reason. So, of course, this is a very rudimentary example, and it has to be compelling on the facts. A more cynical bit of advice you sometimes hear is, if you're weak on the facts, you pound the law. If you're weak on the law, you pound the facts. And if you're weak on both, you pound the table. So there is some truth to that, but you can't win a case by focusing on your strengths. Personally, I think that you win or lose a case on how well you deal with the holes in your case. And every case has holes, and every case has strengths and weaknesses. Now, last but not least, my third and final set of points has to do with knowing yourself. And I think it's fitting that I have Socrates on the slide here. Some would say he is the archetypal advocate. He also looks like a lot of arbitrators. He's even got a pandemic beard in this picture here. So Socrates said that the most important aspect of knowing yourself was knowing what you don't know and being humble about it. You can make a lot of unforced errors in advocacy if you get ahead of yourself and lock yourself and your client into positions too early and end up having to backtrack or contradict yourself. Timing is everything in life, and also I would say in arbitration advocacy. Now, a related point is it is essential to maintain your credibility as an advocate with the tribunal. If the tribunal considers you untrustworthy because you either don't know the facts or won't be honest with the tribunal, then the tribunal will tend not to believe you on anything. And if a tribunal does not like you for whatever reason, if you appear arrogant or condescending or overly aggressive, then that could also color their perception of your arguments. Finally, it is important to get to know your strengths and weaknesses as an advocate. Usually, you are not the best judge of those. So particularly if you're early in your arbitration career, it is essential to find someone who will give you honest feedback and help you improve. Now, I've been very lucky in having some great mentors along the way who helped me improve my writing and also oral advocacy, but it's not something that you automatically perceive you need. I thought of myself as a strong writer after law school, where I also worked as a law review editor, but then I went to work as a clerk for a judge, and that judge would edit literally every sentence that I wrote for him. He would just edit and edit, which was amazing because he was actually almost blind. And the clerks had to print everything for him in this gigantic font. So he had reams and stacks of paper that he went through every single day. But he worked painstakingly through every opinion, and what would come out would be truly a work of art. In fact, he is, I think for this reason, one of the most cited judges to this day in US federal court history. And with that, I come to the end of my presentation, and I wish you all the best of luck with your own advocacy, and I thank you for your attention today.
Thank you very much, Dmitry. That's really interesting and insightful. I liked your comparison, comparing arbitrators to Socrates, whom you have to convince. Well, that's really the art of advocacy, I guess. And at this point, we are going over to the next part of our webinar today, the panel. Over to you, Ginta.
Thank you very much, Natalie. And ladies and gentlemen, colleagues and friends, it's a great pleasure to moderate this distinguished panel of practitioners, and I'm quite sure that Dmitry's words of wisdom will be well taken. On this panel, we will be focusing on three main topics, and the people I have with me to do that are, let me introduce Olena Perepelinska from Integrity's law firm in Kiev, Ukraine. And then we have Maxim Kulkov from Kulkov, Kolotilov and Partners law firm in Moscow, Russia. Ruslan Mirzayev, Adrem attorneys in Baku, Azerbaijan. And Valihan Shaikenov from law firm Aequitas in Almaty, Kazakhstan. And Nick Gvinadze from Gvinadze Partners in Tbilisi, Georgia. And as I mentioned, the discussion will be around the three main topics. One being the arbitration law and trends, second, arbitration agreement, and third, about annulment and enforcement of the arbitral awards. And I would like to encourage the participants as well to put their questions in the Q&A section, and we will pick them up at the end of our panel if we have time, and I hope we do. So let's kick off with the first question, and that's about what is the current law, arbitration law, and what is the state of arbitration as a dispute resolution method in your respective countries? Is it becoming more or less popular? Is it becoming more or less regulated? How would you describe your local arbitration institutions? Is there any recent or maybe planned development of arbitration law? I have a lot of questions, and I hope you will be able to provide detailed answers. Let us start with Olena. How are things in Ukraine?
Good afternoon, everybody. Thank you, Ginta, for the question. Thank you, Natalia, for invitation, and for the Arbitral Institute of the Stockholm Chamber of Commerce. It's a pleasure to discuss the recent developments of our jurisdictions here, and Ukraine is an interesting example. So traditionally, Ukraine is quite active in arbitration arena because Ukrainian jurisdiction generates hundreds of international arbitrations each year. The majority of those cases, about 300 per year, are considered under the rules of the local arbitral institutions, ICAC, at the Ukrainian Chamber of Commerce and Industry, and this is like the only and the major arbitration institution. We also have Maritime Arbitration Commission, but it does not have a serious caseload. In terms of regulation and law, we have two different laws for international arbitration and for domestic arbitration. So today we'll talk about international arbitration. So Ukraine's law on international commercial arbitration is based on the ancestral model law in its first initial edition and has only a couple of injections from the version of 2006 version. The last time the law was amended in 2017 during the bigger judicial reform. After that, so we have a joke. We have a tradition that each president of Ukraine should start his own judicial reform, and sometimes it also concerns arbitration-related matters. So once that big reform was completed, then we had presidential election, and new president launched new working group, and that working group started considering amendments to judicial system, including arbitration. So Ukrainian Arbitration Association is traditionally active in the area and tries to assist the official working groups with elaborating and drafting amendments to the arbitration law. And this time we also offered our suggestions to the official working group. That was done in the end of 2019. And our suggestions concerned several blocks: arbitrability rules, arbitration agreement, enforcement of interim measures granted by the arbitral tribunals to actually implement some of the provision of 2006 law, ancestral model law, and also to improve some currently existing proceedings of court assistance to international arbitration. While the official working group is working, so to say, in the beginning of April, Ukrainian government introduced a draft law to the Ukrainian parliament dealing with international arbitration matters. That draft law concerned three groups of issues. A bit of arbitrability. This is a traditional topic. I will talk about it later as well. Then Ukrainian law currently delegates all the powers of competent authority to the president of Ukrainian Chamber of Commerce and Industry. And that draft law suggests to split that function between the president and the Ukrainian courts. That is, all the issues of appointment and challenge should end up before the Ukrainian courts. And third is the procedure of registration of new institutions competent to administer international cases, because currently, as I mentioned, we have ICAC and Maritime Arbitration Commission, and we do not have any procedure for registration or creation of new institutions. So that draft law offers to create such procedure and establishes some criteria for that. So that is, I think, the framework, and let's see how this would develop. Thank you.
Thank you very much, Elena. That was very interesting, and I take it with me that you have a very active community in Ukraine for the arbitration lawyers. Nick, how is the community and the arbitration law in Georgia? Nick, you're muted. Nick, you're still muted.
Okay, sorry about that. Can you hear me now? What I wanted to say is to start with thanking SCC very much for organizing this interesting event, because as I often emphasize, there is a lot of unexploited potential really when it comes to arbitration in this region. So the spotlight was most relevant and timely. As regards our Georgian situation, Georgia has really come a long way in this past decade in terms of both arbitration law and the court practice. And as a result, obviously, popularity and use of arbitration grows as well year after year, I'm pleased to report. But admittedly, it took us quite some time to get there. The history in a nutshell is that it all started with our first law adopted as early as in 97, which was in a way, on the one hand, already a solid first step away from the old Soviet, what's called arbitrage, what used to be called the arbitrage courts, and was also a step towards real party autonomy. But at the same time, the law was quite defective. Suffice to say, it allowed, on the one hand, it was a double-edged sword in a way, because it allowed, on the one hand, the enforcement of awards without any real court review, while at the other end of the extreme, it allowed the courts to change awards altogether. So unsurprisingly, these and other shortcomings, as you can imagine, led to considerable abuse of process, unfortunately. And that naturally tarnished the trust and reputation of arbitration process for many years to come. But we are in 2021 now, and I'm pleased to say that this bad legacy was buried at the start of the decade. You know, the new Arbitration Act was enacted in 2009 and is in force as of 2010 when this new law follows quite closely the language and the spirit, as they say, of both the ancestral model law as well as the New York Convention. And especially after quite substantial amendments in 2015, it can now boldly be said, it will obviously, it will never be as perfect as we wish it to be, but it can boldly be said that what we now have in place is a near perfect, at least, piece of arbitration legislation. Georgian judiciary has also come quite a long way in the meantime, in the sense that they are increasingly competent, increasingly sophisticated when it comes to arbitration-related matters, and also increasingly consistent. What really matters is that they are also increasingly consistent in showing support for arbitration. So other than the law and applicable court practice, of course, what really matters is that the domestic arbitration scene is also increasingly vibrant with increased levels of activity. For example, to give you the example of GIAC, one of the lead arbitral institutions, GIAC is reporting something like 300% increase of its caseload, believe it or not, year on year, while another lead institution called DRC reports that it is now past its 10,000 cases mark in what is something little over a decade of its operation. And both institutions well survived the pandemic with electronic case management systems or other tools in place. Our Georgian Association of Arbitrators, a relatively new but very vibrant organization, also deserves a special mention, and it is very active, with a number of important recent or not so recent already initiatives, be it, for example, the Arbitrator Ethics Code, which importantly a number of arbitral institutions already signed up to, be it the same implementation of brand new accreditation of arbitrators in the past couple of years, not to mention all the trainings, publications, and no less importantly, the most recently, we also inaugurated just earlier this spring the first ever national moot court competition. I think this is what I wanted to say as a general overview, so to speak, and not to forget, lastly, but perhaps most importantly, a major development of recent years was, of course, the start of this new important cooperation between Georgia and the ICC's International Court of Arbitration. Understandably, the MOU that was signed between Georgia and the ICC court only 2 years ago is obviously centered on Georgia. But what needs to be emphasized here is that this really is a development very much of regional importance, since the MOU is aimed at promoting arbitration, not just in Georgia, but in the entire former Soviet region. Also, no need for me to emphasize how much the current leadership of the ICC court has achieved in terms of expanding the global presence and visibility of the court. And I do believe that the court's incoming President-elect Claudia Salomon will bring even more energy to this process. Speaking of Claudia, as someone who has had the privilege to work with Claudia over the years, I can tell you that she knows Georgia and the wider region quite well. And I'm sure she will bring even more attention and ambition to the regional perspective of ICC arbitration that we are encouraging and pursuing all these years. This is all I wanted to say. Gintal, thanks very much again, and look forward to the rest of this interesting session.
Thank you, Nick. Interesting to hear that also in Georgia, the community is active and the arbitration as dispute resolution method is thriving. Now over to Ruslan. How are things in Azerbaijan? I feel like I'm, Eurovision announcer, it's like, now over to Azerbaijan. Your points, please.
It's funny that you remembered about Eurovision when you referred to me. we have been somehow affiliated with Eurovision a lot, probably. So thank you, Ginta. Thanks to everyone participating in this event, and thank you for SCC for organizing this event. It's my pleasure being part of this event. So after listening to inspiring developments from Ukraine and Georgia, I would like to update the participants about what's happening in Azerbaijan. Basically, right now, we don't have very vibrant arbitration community. We don't have arbitration institutions which are active. We have some institutions, but they're mostly idle or inactive, at least for the last few years. Azerbaijani arbitration community is not also developed. We don't have many lawyers specialized in arbitration because the legal market in general is very small, and it doesn't let the lawyers specialize in different fields of law. You can see many lawyers who can represent parties in a criminal trial on the one hand, and tax inspection on the other hand, and then in an arbitration case. So the market is quite small, and there is not big arbitration community. But having said that, I would like to talk about the future. So what is happening and what is going to happen soon. Hopefully we are on the eve of something happening, on the eve of some developments. Currently, Azerbaijan is a model law country. It's 1985 edition of the model law. And we are also signatory to the New York Convention, exceed Washington Convention, and the European Convention on Commercial Arbitration. Currently, there is a process going on. The process is about revising the arbitration law from different perspectives. First goal would be to make it more in line with 2006 edition of the ancestral model law, as my colleagues mentioned, that for example, in Ukraine, there has been something similar, making the law more in line with 2006 edition of the ancestral model law. In addition to that, the government is discussing to make interim measures more, let's say, available and more efficient. Because until now we don't have mechanisms for enforcing interim measures adopted during arbitration, and we don't also have mechanisms for applying directly to courts for interim measures. So the new draft law is also going to address that issue, and also the law is probably going to address issues such as let's say accreditation and more regulation of arbitration. That's one of the perspectives that is currently being discussed. On top of that, the government is discussing introducing domestic arbitration. We don't have domestic arbitration. It's not regulated at all. So it means that we don't have it because we need some kind of procedure in the legislation to make it possible, but we don't have any regulation of the domestic arbitration in Azerbaijan. So by amending the law on international arbitration, it will be applicable to both domestic arbitration and international arbitration, which is the case in Georgia, for example, I believe. So, and then some other initiatives are about, let's say, defining arbitrability. Our law doesn't define arbitrability and which disputes are arbitrable and which disputes are not arbitrable. So these are the initiatives, the directions of the initiatives happening with regard to lawmaking. In addition to that, the European Union is supporting the Azerbaijani government in terms of promotion of arbitration. Under the EU project, it is, let's say, stipulated that initial basic training of arbitrators is going to happen, and then training of attorneys, training of judges in arbitration, and certain promotion and capacity building events for stakeholders are going to take place in Azerbaijan. So that's basically what's happening about arbitration in Azerbaijan.
Very interesting. And we will see what the new act will bring and how it will be taken, you know, by the practitioners and parties, and how your first domestic arbitration cases will look like. That's a very interesting development. How about Kazakhstan, Valihan?
Hello, everyone. Thank you, Gente, for the floor. Well, I think that traditionally my colleagues, my neighbors, make me jealous. I think I will be a little bit more reserved in assessing the prospects for Kazakhstan arbitration. Well, for transnational projects involving foreign investors, and I think that would be the key focus for our today's discussion. Arbitration, I think, remains the key method of dispute resolution. And from this point of view, arbitration is very popular in Kazakhstan. And the reasons why it is popular is a different story. Well, first of all, I think it's the lack of trust in the domestic judiciary. And second is the enforceability. Very limited number of countries will enforce Kazakhstan court judgments. Those will be mostly CIS countries, North Korea, China, and a few others. So that explains why you would frequently opt for commercial arbitration over local courts. As far as regulation is concerned, I would say that arbitration in Kazakhstan is over-regulated. It is for sure more regulated now than it had been before the current arbitration law was introduced in 2016. And the general trend, I would say, is towards the strengthening control over arbitration. And I think that the reason behind this trend is the huge share of the state in the economy. According to some estimates, the share of the state in the economy is up to 80%, which means that it is very likely that a transnational project will be implemented with the direct or indirect participation of the state, which also means that if an arbitration agreement is challenged or an arbitration award is challenged, you are likely to end up with either the state or a state control entity on the other side in court. And that is why for a large project, you are likely to be looking for an arbitration seated outside of Kazakhstan and not a domestic arbitration. And there are a few reasons for opting for arbitration in a jurisdiction with a strong and independent judiciary compared to the local arbitration. And as I said, first, Kazakhstan has quite contradictory and generally unfriendly arbitration regulation towards this dispute resolution method. And therefore, if you subject the arbitration agreement or arbitral proceedings to Kazakh law, there will be an increased risk of setting the award aside at the end of the day. The second reason is the well-known country risk, and it might not be safe to leave the fate of your arbitration agreement or arbitration award at the mercy of the Kazakhstan judiciary. Also, among other reasons, I would mention the fact that the arbitration law stipulates that disputes with participation of state bodies, and that is a separate subject. I think we can talk about this later, because in most cases you would understand by a state body the state itself in its entirety, the Republic of Kazakhstan. But also the state enterprises and state-owned companies with 50% or more of shareholding of the state shall be resolved with the laws of the Republic of Kazakhstan applied to the merits of the dispute. And you heard that right. This is an extremely exotic requirement that was able even to surprise Kazakh lawyers, who are no longer surprised by anything. And this requirement appeared back in 2016 when the new current arbitration law was introduced. And I think this is these are a few reasons already enough to consider opting for a foreign seat of arbitration compared to Kazakhstan, which does not necessarily guarantee you that you will get away with certain imperative norms that you might face at the enforcement stage, but that's a separate subject. So yeah, I would conclude on this positive note.
Thank you, Valihan. I think arbitration with the state bodies and state enterprises is a subject of its own, and we will come back, as you mentioned, to the enforcement of the arbitral award. That will be interesting to hear how that works. And now, last on this subject, we have Maxim. What are recent developments in Russia? I think there have been the last few years.
Hello, everybody. Well, there is at least one advantage to have a president for almost a quarter of a century. So we've had just one arbitration reform comparing to Ukraine. Yeah, but the same as in Kazakhstan, I believe Russian arbitration is over-regulated. Because, so reform took place back to 2016 and 17. And so the main result of the reform that nowadays we have just 4 arbitration centers in Russia which have a permission to administer arbitration. So main result of the reform that certain types of disputes, mostly importantly corporate disputes, could be administered only by arbitration center with special permission of the Russian government. And so foreign arbitration centers, they can do the same as well with the permission of Russian government. And so far, such permission obtained by Hong Kong Arbitration Center and Vienna, VIAC. And nowadays, so the applications filed by the ICC and by Singapore Arbitration Center. So they are under consideration. So I hope this year Singapore and the ICC will have such permission. So perhaps the next turn is for SCC. So we'll see the development. And another interesting development is about so-called pocket arbitration center. So maybe you know that it was a ratio behind the arbitration reform to decrease the number of pocket arbitration centers. So the aim was reached. So now we don't have any pocket arbitration centers, but before reform, each big company or state corporation, they used to have such centers, like Gazprom, its own arbitration center, like RZD, its own arbitration center, Sberbank, the same, and so on. And the interesting news that Rostec, Rostec is like a big state corporation, Russian corporation, and under umbrella of Rostec, we have KAMAZ, Kalashnikov, UAZ, and many other big state companies. So Rostec, they introduced a bill under which they have their own arbitration center. So many lawyers called it reincarnation of pocket arbitration centers. And the main argument is, well, we have a lot of disputes with state secrets. And therefore, we have to have our own arbitration center and a list of arbitrators which admitted to hear state secrets. So therefore, we need a special regulation for it. And so the bill to be heard by the end of April, so literally this week, I don't know if they will read the bill or not, but perhaps this year we'll see the outcome of this bill. I think that's it about most recent developments. So I will continue in the next topics. Thank you.
Thank you. That was very interesting, observations from your respective countries, and I must say, I mean, this is still a quite impressive and amazing development, given that for like 30 years ago, the arbitration was virtually non-existent in your respective countries, and I guess that's a very difficult balance, or striking the right balance for regulation and over-regulation. And as we know, I'm myself originally from Latvia, and I would say that people in my impression from the people in the region is that people are very creative, and that shows, the pocket arbitration discussions and things like that. So I think that the state, the governments and the parliaments are left with a difficult and task to strike the right balance in their regulations. But let's move over to the next issue, and that's about the arbitration agreement. If we then look at it, and as I guess everyone else in the auditory as well knows, that the arbitration agreement is kind of a creature of its own. It is judged separately from the agreement that the overall agreement it is included in. And if we look at that special, clause, arbitration clause or arbitration agreement, what would you say in your respective jurisdictions? What are the requirements for a valid arbitration agreement? Does it have to be in writing, for example? That's not the case in some countries, I know. What would be, how about the scope of the arbitration agreement and what we call are disputes, all disputes arbitrable? Can I bring my dispute with, with my family or anything like that? So if we start this time with Valihan.
Thank you, Ginter. Well, I like the academic aspect of this issue. I mean, from the Kazakh law perspective, not as a practitioner though. And the reason is the following: if you have an arbitration agreement with a foreign element or a foreign party, then to assess the validity of arbitration agreement, you would first need to figure out which law governs the arbitration clause. And this is where the difficulties begin from the Kazakh law perspective. And neither Kazakhstan legislation nor courts clearly recognize the choice of the seat of arbitration as a choice of law. Neither they recognize the reference to the seat of arbitration as a jurisdictional clause. Simply put, by prescribing in the arbitration clause that the place of arbitration is England, you do not, from the Kazakh law perspective, choose the law applicable to the arbitration, and you do not, from the Kazakh law perspective, submit disputes related to the arbitration clause and arbitration award to the English courts. And this is not a problem, I think, of the Kazakhstan legislation, because if you look carefully at the ancestral model law or the New York and European conventions, none of these documents articulate the concept of the legal seat. They use the term, the place of arbitration, in a more geographical sense, but not in a legal sense. And the legal meaning of this concept is derived from the court practice and doctrine. And Kazakhstan courts have yet to develop this concept. And that's why I'm saying that it's not the problem of the Kazakhstan legislation, rather a court practice and doctrine that is being applied by, or should be applied by courts. Until then, I recommend that my clients, in most cases, decipher the meaning of this doctrine in terms that are known to the Kazakhstan legislation or Kazakhstan law in general. And in most cases, I recommend that my clients make 3 explicit choices separately. I'd like them to articulate the choice of law governing the arbitration agreement. I'd like to articulate them clearly the choice of law governing the arbitration procedure and the choice of the jurisdiction of courts to resolve disputes related to your future arbitration award, on setting the future award aside, on the validity or conclusion of the arbitration agreement, on appealing against certain actions of an arbitral tribunal, etc., etc., etc. So this is one aspect of to address the question of validity of arbitration agreement. The other exotic requirement that Kazakhstan law provides that may potentially affect the validity of arbitration agreement is the consent requirement. Our law stipulates that an arbitration agreement with state bodies, and we'll talk about this later, I think, state enterprises and legal entities directly or indirectly controlled by the state has to contain a consent of an appropriate regulatory state body. And there are two important aspects of this requirement. And since we do not have time for you to read this wordy and confusing language of the clause of the arbitration law, I will do this work for you. The first aspect is the duty of arbitral tribunal. Kazakhstan law says that the arbitral tribunal shall not have the right to consider disputes between Kazakhstan private parties on one hand and state bodies, state enterprises, as well as state control entities on the other side, on the other hand. So this part of the arbitration law, as you can see, addresses the competence of the arbitral tribunal. And it does not address the competence, the duties of the parties. This means that this provision should only apply to arbitral proceedings governed by Kazakh law and should not apply to foreign law governed proceedings. And this is another reason why you should consider opting for foreign arbitration over Kazakhstan arbitration. But do not forget to make the choice of foreign arbitration correctly. The second aspect of this requirement, consent requirement, is a duty of the state-affiliated party to arbitration agreement. It imposes an obligation onto a state-affiliated entity to seek an authorized state body's consent to enter into an arbitration agreement. And one may argue that this requirement concerns entrance into any arbitration agreement, irrespective of the governing law, whether it's a Kazakh law or an arbitration with a foreign state. But even if so, I think that the failure to comply, and this is not a legal opinion, but my thinking is the following. I think that the failure to comply with this obligation should not typically affect the validity of arbitration agreement. A party that failed to obtain necessary consent, be it shareholders' consent or consent of a regulatory authority, should not have the right to demand that the arbitration agreement is invalid based on its own failure to comply with his or her obligation. And this is what we call clean hands doctrine. You don't go to court with dirty hands. But there are nuances, of course, but we just don't have time to elaborate on that. And the last but not least thing is the nature of state bodies. If you represent an investor, and I frequently represent investors, as you could have guessed, against a Kazakhstan state body, in the vast majority of cases, you are in fact acting not against the state body, but you are acting against the entire Republic of Kazakhstan. State bodies are not and never parties to civil relationship. They only represent the Republic, or they can represent the administrative territorial divisions of the Republic in the same manner in which a CEO or board of directors would represent corporation. And the only instance where a state body, it wouldn't be a state body actually, it would be a state institution, would be acting in its own capacity as a separate legal entity is when the institution has an interest in the contract of its own. And an example of such cases would be the procurement of stationery or toilet paper by a government agency for its employees. In all other cases, you are almost likely dealing with the Republic of Kazakhstan. So in other words, you determine the status of the counterparty not by who signed the contract, not by the name that you see on the contract. for instance, the Ministry of Transport and Communication of the Republic of Kazakhstan, but by the interest that the party has in the contract. And the Ministry of Transport and Communications cannot have an interest of its own in the construction of the Republican automobile road. So this life hack, so to say, may have fundamental implication on your arbitration. So this is to keep in mind. So I think this is like a brief response to the question on the validity of arbitration agreement.
Yes, this was very elaborate and very interesting. And just a short question. Yes, yes or no answer. Are there any cases, case law on this point where you talked about that the state body that enters into arbitration agreement needs to seek consent? Is there any case law in Kazakhstan on that?
Well, I'm involved currently in one of such cases where the opposite side is invoking this argument in an ICC arbitration in Paris. No, not in Paris, in Switzerland, but in any case, yes. I'm not aware, though, of the court practice on this subject. So not yet it was a yes/no question, yes.
Ongoing, good. If we move to the next speaker on this topic, I would like to ask the question to Maxim about the scope of the arbitration agreement.
Okay, well, maybe I'll talk about very narrow topic, namely validity of an agreement if it's considered by the rules of a foreign arbitration center with a seat in Russia. As you know, well, according to this reform 5 years ago, so the arbitration centers in Russia, arbitration centers only with permission of the government can administer the disputes. All other disputes considered as ad hoc arbitration. And for a foreign arbitration centers, it's a little bit different. So a foreign arbitration center may consider Russian disputes except corporate disputes. For this, they need a special permission of Russian government. And recently, in several cases, the question of if it's a foreign arbitration center, but a Russian seat, so what to do with such a center. And so we have two groups of cases. So first group of cases is so-called fake foreign arbitration centers, like Russian Singapore arbitrage or Helsinki International Commercial Arbitrage. So these arbitration centers, so they are registered abroad, but in fact there is nothing else, no other connections with abroad. So it's Russian arbitrators. The office is here in Russia, and everything is Russian. So they just registered a small office abroad in order to avoid the requirement of Russian arbitration law. So to enjoy such an privileges given to foreign arbitration centers. So they don't have to obtain a Russian government permission. And so in most recent case, pardon?
No, I was just saying that this is the example of people being creative, right?
Yeah, people being creative. And in very recent case, so it's a Krovля Profi against Rost, two Russian companies, and the dispute was considered by HICA, so-called Helsinki International Commercial Arbitrage. So the case went up to the Supreme Court, and the Russian Supreme Court, they said, well, no, it's not a real foreign arbitration center. And so they used Article 10 of the Russian Civil Code, which expressly prohibits abuse of right. And so the Supreme Court stated that it was a clear abuse of right to establish such a foreign arbitration center. So therefore, the arbitration agreement is invalid as contradicting Russian public law, and therefore the award is null and void as well. And on the opposite side, so another case administered by the Stockholm rules, SCC rules. I was a chairman in that case, and I can talk about it because the case went through state courts during its award enforcement. So it was under SCC rules, but with a seat in Moscow, and it was a dispute between Caspian Energy versus Siemens over a rig in Caspian Sea. And in that case, so the award was enforced by Siemens. And on the first circle, the court in Astrakhan, they denied award because they applied the same logic as to the fake foreign arbitration centers. So they said that, well, because it's with a seat in Russia, so it should be considered as ad hoc arbitration. And because it was administered by Stockholm chamber, so therefore its award contradicting Russian public policy. But on cassation level, so the cassation court reverted the case, and on the second circle, so the award was finally enforced. And the court said that, well, this rule applied only to Russian arbitration center. So if they have no permission, any such arbitration considered as ad hoc. But if it's a foreign arbitration center, so they can consider Russian arbitrations, and they are not considered as ad hoc arbitrations. So that's good news for SCC and all other arbitration centers which still not yet have Russian government permission to administer arbitration. Yeah, I think that's it about Russia on this topic. Thank you.
Thank you, Maxim. It's always interesting to hear what are the latest case law developments, because it tells us more about how the law is applied and how the arbitration is viewed in the respective country. And on that, Ruslan, what would your take be on the arbitration agreement and its validity, requirements, and scope?
So as I mentioned, Azerbaijan is an ancestral model law country. So the requirements for an arbitration agreement is kind of the same as it exists under ancestral model arbitration law, which is just writing requirement. And also we had experience in enforcing an arbitration agreement, which was in the general terms and conditions, which wasn't signed by the parties. Just parties signed a contract which referred to a general terms and conditions, which included an arbitration clause, and we were able to enforce that arbitration agreement before the courts, and the court referred the case to arbitration. So that's basically about the form, or let's say form of an arbitration agreement. In addition to that, I want just to shortly mention about arbitrability in Azerbaijan. Currently, we don't have any specific provision about which disputes are arbitrable and which disputes are not arbitrable. As a matter of practice, issues that belong to the exclusive jurisdiction of Azerbaijani courts, they are considered non-arbitrable. They include disputes about real estate, disputes about patents and trademarks and other IP rights, and it includes, let's say, claims against international carriage companies and disputes about annulment of corporate decisions and dissolution of companies, etc. But currently, within the scope of this new reform, I believe the new law will specifically regulate which disputes are arbitrable and which disputes are not arbitrable. So I'll make it. I try to make it, let's say, brief.
Thank you, Nick. How about the requirements in Georgia?
Thanks, Ginta. Thanks, Ginta. On this topic of arbitration agreements, just like what Ruslan said, again, our law is quite modern and it is closely in line with the model law. And at the same time, so there are no major noteworthy deviations from the model in terms of the requirements for the written form, which is broadly put. And fortunately, the courts also are increasingly, as I already noted, supportive of arbitration, and they are increasingly enabling towards arbitration, which obviously starts with considering the validity and recognition of arbitration agreements and their effect. So no real burning issues to be reported, except for Maximo was also mentioning ad hoc agreements. And if one would single out a problem area that is with recognition of clauses that provide for ad hoc arbitration. And the problem is that not in recent cases, because there is really no recent case in this regard, but in older cases, in some older cases, there is quite concerning dicta. In several cases where the courts indicated that they would not uphold arbitration clauses that fail to refer to a specific arbitral institution that is to administer the case. Unsurprisingly, this problem comes from the legislation in the first place. And again, as originally enacted, our current Arbitration Act was not really clear on this as it should have been, and unfortunately, later changes, and in particular the substantive changes that I was mentioning of 2015, also failed to adequately address this issue. So there is no explicit express statement in the law, despite obviously all the so much of the model law, you will agree, is about administering and allowing ad hoc arbitration. But so it happened that the part regarding arbitration agreement does not expressly say that the parties can go to ad hoc arbitration, while it does emphasize that parties can choose to resort to international arbitration, institutional arbitration. A related problem that I also wanted to mention quickly in this context, or in this same context of ad hoc arbitration, is that the law also does not specify what happens where, again, in an ad hoc setting, the parties fix the seat to arbitration broadly as Georgia, without specifying which concrete city or district they are referring to. And the problem here is that in this case, an additional problem can be that you may not know which court to resort to for the same appointments or other support, because the first instance courts, there are many. So there needs to be a default rule where parties will go in the absence of such specificity in the agreement. And unfortunately, changes are already in the pipeline, and hopefully these both problems with ad hoc clauses, with the recognition of ad hoc clauses in general, and with providing a default rule, and the default rule in case of the seat and in case of the relevant court would be Tbilisi City Court as the largest first instance court, where the parties would by default go to. So this is one problem I wanted to that came to mind, and I wanted to flag. Other than this, except for this isolated problem with ad hoc arbitration, the case law is quite pro-arbitration here as well. Courts are, again, inclined towards broad and enabling interpretation of arbitration agreements. For example, there were more recent two very interesting cases where the respondents unsuccessfully tried to defeat respective arbitration clauses on the ground that the clause referred only to the institutional rules and it did not refer to the actual institution as the one to administer the dispute. The case is concerned that these reported cases were about GIAC in the first and the ICC arbitration rules in the second instance. And in both cases, the court very helpfully upheld the validity of the agreements, effectively establishing that a reference to arbitration under institutional rules equals a reference to arbitration administered by that same arbitral institution. By the way, later in the ICC case, there was an additional important development. The case went all the way up to the Supreme Court, and at the Supreme Court level, the party that defied arbitration, the respondent, used an additional argument, put up an additional argument saying that the agreement only provided that the dispute could be the dispute may be referred to arbitration rather than must be referred to arbitration. And fortunately here as well, the court very clearly put down solid case law and established that the parties may refer to arbitration statement in a clause in an arbitration agreement is quite a valid and enforceable agreement. And if one of the parties exercises such choice, then the other party has no option but to submit to arbitration. This is, I think, in the little time that we have, these are the comments I could offer. Thank you.
Thank you, Nick. Olena, would you like to elaborate on this? Do you see any of the concerns that your fellow panelists have in their countries? I mean, in terms of ad hoc or written requirements?
In Ukraine, we also have written requirements. I think this is traditional for the region. However, in 2017, this written requirement was amended a bit to implement partially the version of the Amsterdam Model Law version 2006. And actually, it now allows to have an electronic form of arbitration agreement and treats as a written form. However, despite this provision of the law on international commercial arbitration, you should be minded that the procedural law is not adequately adopted to that provision, and our civil procedure code still requires, for enforcement purposes, that the creditors submits either original or notarized copy of the arbitration agreement. That would be difficult to do with an electronic form of arbitration agreement. In terms of scope and arbitrability, so again, this is very controversial, traditionally controversial topic for Ukraine. The rules on arbitrability have been amended several times, last time in 2017. And interestingly, that some amendments finally introduced into the Commercial Procedure Court were inspired by the Swedish arbitration law. And in particular, this formula of civil law aspects applicable to competition claims in Swedish Arbitration Act. I'm not sure how it's translated adequately, but the law says civil law aspects, and this formula of civil law aspects was used by Ukrainian legislature to somehow to make arbitrable certain claims in public procurement, in privatization, in unfair competition claims or competition, and there are also some limitation to corporate disputes, and we have a gap and very unfortunately worded provisions regarding to insolvency. And whenever you have a party, Ukrainian party, undergoing insolvency proceeding, you could have problems. Yes, Ginter.
And it's maybe only mine, but I feel like your sound is fading away. Maybe you can readjust something here or so.
I will try.
That's better.
It's better? Okay,
Yeah.
sorry.
Sorry.
Yeah. And so you should be very careful with insolvent Ukrainian parties because you might have problems with arbitrability issues as well. And one positive aspect of the recent reform is that now we have provisions in procedural codes obliging Ukrainian courts to treat in a very pro-arbitration way any defects of arbitration clause. So whenever the court see any defects, the court is obliged to treat those defects in favor of validity and enforceability of arbitration agreement. And this changed drastically the court practice of in Ukraine, because previously they were very formalistic and they used any defects to refuse the enforcement or for setting aside the arbitral award. This is not longer the case. I think this is enough for the topic of arbitration agreement. Thank you.
Thank you very much. That was quite a good overview of the current state of what are the regulations surrounding arbitration agreement and what are the recent case law, and very interesting indeed. But if we now go over to the next and our last block of questions, and it happens to be my favorite question of annulment and setting aside of the awards and the enforcement of the award. And I guess from the practical perspective of the parties, that is also one of the most interesting practical issues on what do you do with the arbitral award after once the arbitral proceedings are over and you finally got your award. How do you go about it? And both if you have lost the arbitration and if you have won the arbitration. And the issue with the annulment and set aside is obviously about trying to annul or set aside the arbitral award, and is for the respondent, so to speak, to do. And the issue of enforcement is for the not the respondents, I'm sorry, for the losing party. And not that I would ever assume respondents being the losers, the losing party, and then the enforcement is for the winning party. And so I suppose there is some case law mainly about this in your respective countries, and I would be very interested to hear about is there what is the general status, and are there any trends towards being more inclined or the opposite towards the enforcement and set aside of the arbitral awards? And here I would like to start with Maxim.
Okay, well, again, I dedicate this only to one narrow issue. Last summer, there were some amendments into Russian Commercial Procedure Code, basically about considerable change of basic jurisdiction rules. So it means that if a Russian company or individual which is under Western or Ukrainian or any other sanctions, and if such a person cannot properly defend its rights in a broad forum, so this person can apply to a Russian state court, state commercial court, for a change of jurisdiction rules and for protection. So basically, for example, if a Russian company under sanction, like, I don't know, VTB, has a arbitration clause for, I don't know, SCC clause, with a foreign entity, and if this Russian, and if VTB believes that it cannot properly defend its right under SCC rules, so it can apply to Commercial Court of Moscow for change of jurisdiction rules and to consider the case on the merits in the Commercial Court of Moscow. And so since last summer, so we have some case law, and one quite interesting recent case, very recent case, it's Power Machines against its Russian company, you know, it's a subsidiary of Severstal, versus Nasos Energomash, a Ukraine company. And Power Machines, so they obtained successfully obtained award under the ICAC rules, I mean Russian ICAC, against Nasos Energomash. And they tried to enforce this award in Ukraine. And the Ukraine court denied enforcement. And basically because Power Machines, they missed a 3 years term from the date of the award. But Power Machines, they then applied to Commercial Court of Moscow. And the argument was that due to Ukrainian sanctions, because Severstal, our parent company, is under Ukrainian sanctions, so they couldn't properly defend our rights in Ukraine. So therefore, we apply for enforcement of this award to Commercial Court of Moscow, notwithstanding that Nasos Energomash, they don't have any assets in Russia, so there is no link to Commercial Court of Moscow. And Commercial Court of Moscow, they enforced the award. And so interesting enough that they didn't really studied the reasons why Ukrainian court denied enforcement, because as I see, at least from from the court order, so Ukrainian court denied not because Power Machines are under sanctions, but just because they missed 3 years time. So the award is not fresh enough, I would say. But anyway, so it gave a good chance for Power Machines to do it in Moscow Commercial Court. So that's quite interesting example of application of this new law. And there is another case, a quite opposite case, also famous case, Ural Transmash, a Russian company, against Peka, it's a Polish company. And so in this case, so the parties, they have arbitration clause referring the disputes to SCC. And Uralmash, they applied to a Russian state court, and they said, well, we cannot properly defend ourselves under the SCC rules. Therefore, Russian state court should hear this case on the merits. And in this case, all 3 instances, so recently it was a decision of the Cassation Court, so they denied such application of Uralmash. And they said that just a mere fact that you, Ural Transmash, under sanctions is not enough to prove a jurisdiction of a Russian court instead of jurisdictions of the SCC. So you have to prove that you really face obstacles to defend your rights in Stockholm. So, for example, Ural Transmash, they argued that they cannot really arbitrate under the SCC rules, but Russian court said, well, you already are have been arbitrating for 2 years, and Russian lawyers and the Polish lawyers defend you, and you successfully pay the arbitration fee. So nothing really stop you from defending your rights in Stockholm. So therefore, we don't admit our jurisdiction to hear this case on the merits. So that's another good example of application of the new law, quite opposite to the case Power Machine against Nasos Energomash. I think that's it. Yeah, thank you very much.
If I may, just a short follow-up question. What would you say is what kind of circumstances would be such that, that this sanctioned entity has to show that it is not able to arbitrate? What would that be?
Well, I think, well, first is maybe problems with composition of tribunal. So, for example, if one by one arbitrators, so they don't accept appointment due to the sanctions. Second, if a party to arbitration has real issues with payment of an arbitration fee, so therefore the case is on hold. Third is that perhaps, well, if a dispute is governed by a foreign law, say English law, and English lawyers, one by one, they don't accept the instruction due to the sanctions. So they deny, defend, I don't know, Severstyle, for example. So I think these three basic examples of possible real obstacles.
Right, interesting. Olena, how about the Ukrainian courts?
So Ukrainian courts demonstrate more and more arbitration-friendly approach and court practice. So if we start with statistics on setting aside of arbitral awards, as I mentioned, we have one major institution, and it's very easy to track the number of awards rendered and set aside in Ukraine. So Ukrainian ICAC renders about 200, 300 awards per year. And if we look at last 5 years, not more than one award per year is set aside by the Ukrainian court. So that is less than 1%. And based on that, it's possible to say that it's close to impossible to set aside an arbitral award in arbitration seated in Ukraine. In terms of enforcement, we don't have yet such clear statistics. In Ukrainian Arbitration Association, we are finalizing a great project with regard to statistics of Ukrainian practice for the recent 15 years on enforcement of arbitral awards. So we will have clear figures soon. But now I could say that in the last 5 years, the success rate is above 85 or even 90% of all the cases. So again, Ukrainian courts are reluctant to refuse enforcement. It's interesting. So today sanctions were mentioned, and with sanction we have our own court practice. But turning to the most probably popular in the region ground public policy, Ukraine is quite specific and unique in applying that concept, because more than 20 years ago, the old Supreme Court of Ukraine provided a notion of the public policy. That notion was very narrow, and this 20 plus years, Ukrainian courts follow that notion. And this, again, makes almost impossible to gain an argument of application of public policy exception. If we look at the statistics of the last 5 years, I think all the refusals to recognize and enforce an arbitral award based on, do you hear me?
Yeah, you're breaking away and fading a little bit. So maybe if you.
In last 5 years, the number of cases, the number of refusals based on public policy could be counted on one hand. So that is really very rare, but some of those cases are related to sanction policy and sanctions of Ukraine, and some of them concern Russian entities, sanction entities. In general, as I mentioned, the court practice is very arbitration friendly, and some recent court judgments of the Supreme Court demonstrate really more profound and pro-arbitration approach, and this is really interesting to monitor and to experience as an arbitration practitioner working in this jurisdiction. And with regard to this power machine case, I think that Ukrainian requirements of 3 years deadline is quite typical for the region. So it's nothing new. I think this exists in many other jurisdictions in Russia, including, so that the creditor should start enforcement proceeding before the expire of that 3 years period. So, but still, it was interesting to know that approach of the Russian court. Thank you, Ginta. That's all.
Great. Maybe just a technical issue. You know, when I was little, we were watching TV and we had to keep the hand on the TV, and then it transmitted better. Maybe if you keep your hand at your headset, maybe it will help the going forward. And how about Nick? How about practice for setting aside and enforcement in Georgia?
Thanks, Ginta. All very well in both regards in Georgia. Again, in this aspect also, our Arbitration Act that I already mentioned several times, it follows quite closely the model law and the New York Convention in terms of the grounds for the annulment and enforcement, which are practically here in Georgia, the grounds for the annulment and enforcement, they're practically the same, as they mirror the same Article 5 of the New York Convention. But there is a notable procedural difference in the sense that the requests for the annulment of domestic Georgian awards, as well as for recognition and enforcement of the same domestically made awards, go to one of the two appellate courts. We have two appellate courts, one covering East Georgia out of Tbilisi and the other one covering West Georgia out of Kutaisi. So you go for domestic awards, be it for the annulment or for recognition enforcement, you go to one of the two appellate courts. Whilst the recognition enforcement of foreign awards that are made outside Georgia are directed to the Supreme Court of Georgia. Okay, so otherwise grounds are the same. So here as well, I would say that the same positive trend is observed that I was already mentioning with respect to arbitrability arbitration agreements, pro-arbitration, arbitration-friendly approaches, what we enjoy from our courts, and increasingly so. Repeatedly, the appellate as well as the Supreme Court have repeatedly said that the court is not allowed to reconsider a dispute on the merits. That is one. So even where it is clear that the arbitral tribunal erred in its factual or legal findings, it is not allowed to reconsider, reopen the merits of the dispute. And at both levels, at the appellate as well as the Supreme Court level, the courts have unanimously said that, you know, if this is not the case, then such annulment proceeding would simply become an appellate mechanism, which would in turn obviously violate and be against both the New York Convention as well as Georgian Arbitration Act, which both uphold finality of arbitral awards. And secondly, as Lena was also pointing out, of course, you will not be surprised that another key key aspect to enabling and pro-arbitration approach is, of course, is the increasingly narrow interpretation and application of the public policy exception. And again, this applies in the context of both the annulment as well as recognition and enforcement. And here, Georgian courts have repeatedly declared that public policy denotes not any type of violation as such, but only disregard for the fundamental principles of law. In other words, in order for an arbitral award to be revoked on the ground of its conflict with public policy, it needs to contradict with higher values. Otherwise, again, the public policy will again be turned into another appellate mechanism to arbitral awards, which is strongly discouraged. You will agree, that this all sounds like music to our arbitration-friendly ears, but of course, nothing is quite rosy. There are issues. There have been issues in the past. One significant issue, I would say, that was already successfully handled and resolved by what I mentioned about 2015 amendments. The substantive amendments in 2015 got rid of this major problem, which was with the applicable court fees. And the problem was that practically for recognition enforcement, you were required by the previously applicable law to pay the same court fee that you are required to pay for launching a brand new lawsuit in the Georgian court. So the court fee was the same for recognition enforcement as payable for filing a new civil claim, which obviously made no sense, very simply because then that meant that arbitration was much costlier, because you were adding up what it would cost you in the courts, plus, of course, all the applicable arbitration costs. So that was, fortunately, promptly reconsidered. So that issue is now well in the past. But there is another more recent issue that has surfaced and that we are still struggling with. This unresolved issue is the delays with the enforcement process. I was mentioning the lead arbitral institutions, same DRC and the GIAC, they boast that they can resolve your dispute in something like 3 to 5 months. And then when you go for the enforcement stage, when you go to the courts, there can be a very serious backlog of cases, and it may take another 6 to 12 months from what we are hearing and understand, in terms of the time delay, because of, again, the overload of Georgian courts.
Okay.
By law, by the way, this is not a statutory problem. This is not in the legislation. It's not, because it's only 30 days. So it's a fixed deadline there. But in a way, you can understand Georgian courts also, because last time I checked, they had they're handling unbelievable amount of cases. I think it was 50,000 cases, around 50,000 cases annually last time I checked. So it is not an easy problem, but let's hope the practice will improve. Okay.
Thank you. Thank you very much, Nick. And now we have Ruslan. How about your perspective?
Just generally, I as Valkhan noted, how courts treat arbitration is very important for development of arbitration, and you cannot take arbitration out of the court system. So if you want to have a developed arbitration system, you need to have a developed court system, and I believe all other, let's say, initiatives have been proven not efficient. So that's why it's very important to see how courts treat arbitration. In Azerbaijan, when talking about annulment proceedings, it is the same as the model law. The only difference is that instead of public policy, our law refers to the constitution of Azerbaijan. So basically, if an award is against in breach of the constitution of Azerbaijan, that award may be annulled. But other than that, the courts cannot refer to public policy when it comes to annulment proceedings. But when it goes to if we talk about recognition and enforcement proceedings, that's a different story, because we are signatory to the New York Convention. We have law on international arbitration, which is based on ancestral model law. We have two completely different provisions of the Civil Procedural Code regulating the recognition and enforcement. Basically, we have 4 different laws regulating recognition and enforcement of foreign arbitral awards. So you can say that, but that's not an issue, because the New York Convention stands higher than the national laws, because in our systems, international laws stand higher than the national laws. But the international treaties actually stand higher in the hierarchy than the national laws. But that's not the case in the court practice in Azerbaijan, because many courts wouldn't refer to the New York Convention in their decisions. The situation is getting a little better, but it hasn't been resolved. The issue hasn't been resolved. Even in cases where both parties refer to the New York Convention, you can find a court decision where there is no indication that there is such convention. I don't know what's the reason for such an approach, but one of the reasons may be that there is no official translation of the New York Convention. So it was adopted, I don't know in which language, maybe it was adopted in Russian or it was adopted in English, but there is no publicly available Azerbaijani translation of the New York Convention, and the courts do not refer to the New York Convention. And we also have the issue, as Nick mentioned, about the duration of the process. We don't, unlike Georgia, we don't have statutory limit for the recognition and enforcement proceedings. So there is no set period, fixed period for that proceeding. So it's up to the Supreme Court to decide without any time limits. Just before going into more details, I just want to share one slide, briefly. I think it may be helpful. I like this slide because it shows the trends. So if you analyze court decisions from 2005 and 6, I analyzed many decisions, and in only one of those decisions, the court referred to the New York Convention. In no other case, the court referred to the New York Convention, and the court judgment which referred to the New York Convention on recognition and enforcement also referred to the national legislation. So it said that the award is in line with the Civil Procedural Code and also with the New York Convention. So I don't know what would have happened if that was not in line with the national laws, but in line with the New York Convention. So, but if you analyze the decision from 2011 and 2018, nearly half of the cases didn't refer to the New York Convention, but the good part is that the other half referred to the New York Convention. So that's the progress, I would say. But the most cases that refer to the New York Convention, they also refer to the national law, saying that we are going to recognize this award because this is in line with the New York Convention and also with the national legislation. I mean, national legislation on recognition and enforcement. The major cause for refusal of the recognition and enforcement was the lack of proper notice, which exists in our legislation and under the New York Convention as well, and under the ancestral model law as well. So in all the cases I reviewed, the reason for refusal of the recognition and enforcement was the lack of proper notice. But what happened in 2019, I was also invited as an expert to the Constitutional Court to opine about the proper notice under the New York Convention. And the Constitutional Court decided that the burden of proof on proving that the respondent didn't receive proper notice is on the respondent to prove that the respondent didn't receive the notice, not on the claimant, not on the party seeking the recognition and enforcement. So after 2019, it seems that it will be very difficult for courts to use the lack of proper notice as a ground for refusal of the recognition and enforcement, but we haven't seen yet any decisions. I haven't seen actually any decisions since last year. So that's kind of brief introduction about what's happening with regard to recognition and enforcement in Azerbaijan.
Thank you, and I think we will all agree that lack of proper notice is one of the most commonly used arguments, alongside with the ordre public, the public
policy.
Thank you. Valihan, how are things in Kazakhstan?
Thank you, Ginter. Well, I think I would start by answering the question of Anya Sashko, who is asking about the enforcement of interim measures ordered by International Arbitral Tribunal. And I think this is very relevant. The Kazakhstan Supreme Court expressed its view, although not binding on lower courts, that the arbitral tribunal, the arbitral tribunal's awards should be enforceable under the New York Convention, and whether they are enforceable should be determined not so much by the title of the act, whether it's called interim or it's called partial or otherwise, but by its compliance with three main conditions. The first one is that the award is rendered by the arbitrators, needless to say. The second one is that the award is finally resolves a specific claim, and then it is binding on the parties. And I think this is good news for such cases when, for example, in construction dispute, an arbitral tribunal renders an award on enforcing a dispute adjudication board's decision, for example. And very frequently such awards, for some reason, in my practice, but not only in my practice, I think it's a well-known fact, are named as interim awards, although they finally resolve a specific claim and are binding on the parties. So for that type of interim awards, you might have a good case before a Kazakh court to enforce them with reference to the position of the Supreme Court. And there have also been cases where Kazakhstan courts enforced acts of foreign arbitral tribunals on taking measures to secure a claim, and those were essentially interim awards. So the answer to Anya Sashko's question is more positive than negative. As far as court practice is concerned, we have very limited information on the court practice, particularly as far as enforcement of foreign arbitral awards is concerned, unlike our neighbors in Russia or Ukraine. And the biggest problem here is the searchability of the database, and you can't really run a search by general criteria. So unless you have some information in the newspaper about the case, it's difficult to get a general picture and make a search by a general criteria. Last but not least is the bad news. And the bad news is that neither the New York Convention nor European Convention were duly ratified by the Republic of Kazakhstan. Kazakhstan joined these conventions through an ordinary decree of the president, putting the convention in the hierarchy of regulatory legal acts, actually below the laws, which means that in principle, although this has not been tested in practice, to the best of my knowledge at least, where there is a contradiction between the convention or one of both conventions and the Kazakhstan laws, including the civil procedural law and then the arbitration law, then the latter would apply. So we can talk about the discrepancies about the New York Convention, European Convention, and the domestic regulation. But I think from what I have already said, it becomes quite apparent that there are lots of exotic deviations and discrepancies. So I wouldn't like consume any more time on this subject.
Thank you very much, Valihan. And by that, I see that we have already taken over more time than we were allocated to do. But I would like to thank all the panelists for sharing their insights and being well prepared. And I hope we will be able to continue this discussion in the next coming forums. And I think there are a multitude of also questions that have been submitted by the audience, and we will be able to dwell into those in another occasion. Thank you very much. And now over to you, Natalia.
Thank you very much, Ginta, and everyone. That was a really unique session. We got a fantastic overview of what is going on in the focus countries. And now I think that at this point, we leave the floor to Patricia Shaughnessy, an associate professor, founder and former director of International Commercial Arbitration Law Master Program in Stockholm and former vice chair of the SCC board. Patricia will be interviewed by the Secretary General of the Russian Arbitration Association and founding partner of Mansour's law firm, Roman Zykov. Over to you.
Thank you very much, Natalia. Can you hear me well?
Yes.
Good afternoon, everyone. Good afternoon, Patricia. Good to see you, although I wish to see you in person. It's a tremendous pleasure for me to be a part of this forum, and of course, a great pleasure to interview our special guest, Patricia Shaughnessy. Everyone knows Patricia. She doesn't require any introduction, but for the sake of, just for the record, I will say that Patricia has extensive knowledge on CIS region. She arbitrates and she counsels and she acts as expert. And that's what we want to know, actually. Patricia being a US person and then traveled a lot, and eventually she developed this wonderful international profile as arbitrator. So the focus of our interview, and unfortunately it's very short, will be on how to become an arbitrator and how to make yourself an international arbitrator. Well, good afternoon, Patricia, once again. Good to have you.
Thank you, Roman.
I would like to start off with this simple question: how to become an arbitrator? How did you get your first appointment?
Well, like many first appointments, mine came through an institution, and I was happy to receive it. I had not been in contact with the institution. I had not been seeking appointments, so I was happy when I got an appointment.
Right, right. So it was, you didn't come to that, you didn't plan that, but it was somewhat accidental. Is that the way?
Well, I guess that kind of leads into, how you get them. I had been active in international context of international arbitration for quite a while. And people at that institution had also been at various events that I had been at and speaking at and such. So I knew who they were, they knew who I was, but I had never reached out or in any way sought to get an appointment.
Right. What will be your tips for younger practitioners, I mean, starting arbitrators, how to get your first appointment?
Well, maybe the first thing is to ask, why do you want to get appointments? Is it something that is perceived as, the next step in your career, and to ask why? But assuming that you know why you want to get appointments and how that will fit in, I think that the important thing to do is to first get competence and build experience in your home jurisdiction, and then to, at the same time, be making yourself more visible outside of your home jurisdiction, because you're not going to get appointments outside your home jurisdiction if you don't have developed competence and if you haven't developed visibility outside of that venue.
Okay, well, makes sense. Do you think social networks may play a role today?
You're asking the grappler. No, well, actually, but social media has not been something which I've been particularly interested or active in, although more recent times I've gotten more active in LinkedIn. I think that you have to be very deliberate and intentional in your career. And I think when you engage in social media, you need to be sure you intentionally curate that, because you want to keep a professional reputation and a professional engagement. And indeed, you see very few of the very established and often appointed arbitrators very active in those environments. You should be a little selective about the kind of comments. And so I would say intentional, curate it. I can note behind you there, it looks like there's a construction helmet.
It is, in fact, yes. I wish I would be a cat or a dog to make me more human. But
that's kind of a good, I mean, it gives the impression when we see you now looking very professional, along with all your law books, the impression, the message that I get, not so subconsciously, is this is a guy who's familiar with construction dispute and construction industry, engineering infrastructure. There's a little message there.
Thank you. Speaking of which, do you think specialization is important, like in construction or telecom or IP disputes, to become a successful arbitrator?
Well, statistically, according to statistics from some of the major institutes, being specialized in construction, infrastructure, and energy is going to put you in the top half of the caseload. So that's probably a good area. But let me emphasize, particularly for relatively younger people who are still establishing their practice, both as counsel and hoping to move into appointments, it's really important to have a solid competence in commercial law and to understand commercial law from a legal perspective and from a client perspective, to understand the basics of commercial law. And it's also important to have a good understanding to be able to work with procedure, litigation procedures, different procedures, because arbitration is procedural. And as an arbitrator, you need to be able to manage and make decisions often quickly about procedural issues, and at the same time be able to manage the commercial realities. Very few clients will want to appoint an arbitrator that doesn't have solid commercial understanding. And so specialization is good, but I think that you need to build that on the foundation of solid commercial understanding and experience, combined with understanding how to manage the procedural aspects of dispute resolution.
All right, so perhaps it makes sense for a lawyer to spend some time within transactional groups, M&A groups, telecom, within a law firm, or even as in-house to get insights on a particular field of business. What do you think? Does acting as counsel or expert necessarily translate into becoming an arbitrator in the future? Is it important?
Yes, I think it's quite important, and maybe I spent the first 10 years of my career as working in a commercial law firm with a specialty in primarily litigation, although I first got certified as an arbitrator back in 1985. And I think having that experience, and I think it brings, when I sit as an arbitrator, perhaps clients or parties appearing before me may think I'm a bit quiet. That's partly because I'm very much aware that counsel has spent a lot of time getting to familiarize with this case, and there may be different things going on with the case that I don't see on the surface, because as they say, their file's this big, my file's that big. And usually I find if it's good counsel, the questions that are bubbling up in my mind get asked and get resolved. And so I'm often trying to take in the information and let counsel present the case. But that is a reflection of perhaps my 10 years of experience.
All right. What will be your top, say, 3 tips for increasing your international visibility as arbitrator?
One, be authentic, be genuine, really genuinely interested, curious about learning new things and meeting new people and engaging and building a network, not because you're trying to see how many people you can get to friend you on Facebook or LinkedIn you or whatever, but because you really are interested in participating in this community, that you get involved in activities. So that's to get involved in activities, organizations. Most arbitral institutes have ways that you can get involved in the institute and become more familiar, arbitration organizations, and even business and others. Even old people like me, I just recently joined the ICC informal working group on human rights and CSR issues. I think those are interesting and important, not because I'm trying to build my network, but I'm interested in getting involved, but I will learn from that too.
Perhaps writing and speaking and, I don't know, but research, is it an important part of the equation?
Yeah, I think it shows that you're interested in what are new trends and commenting on new cases, sharing new developments in areas that you're interested in, your home environment. I think that's important, but you need to be careful that you're doing it with accuracy and precision, so you're not just publishing a bunch of blah blah. And also, sometimes a little surprised in some contexts that some people are willing to give some very strong opinions about very specific controversial issues. And I'm sometimes a little surprised that these persons who may want to become counsel or become arbitrators are so willing to box themselves in with a strong controversial opinion on specific issues. So one needs to be sure that one shows that you have an analytical ability to see both sides or the many sides, and then to critically analyze them, even if you want to suggest a particular outcome. You need to show that you're an open-minded, analytical person.
Right. You have a very strong focus on certain areas of law and, of course, on certain regions, as far as I understand. Do you think it's important to focus on a region, or it just comes on its own at some point?
Well, as I said, you should be intentional. Curated everything. I tend to have followed where my interests and curiosity has taken me, and where opportunity. But I've been really quite happy and pleased that I have had the opportunity to get involved, particularly in the region we're speaking about today, over the years in commercial dispute resolution, and even in some other far-flung areas. And I learned so much. The opportunity to get involved in doing a project of whatever type it may be, to work with different people and to get new input that would have been difficult to get if you just sat down and started opening books. So it's truly a interactive, intense comparative law learning process that's so valuable. And you meet some terrific people.
Indeed. So you should be very consistent. Patricia, I wish I could spend more time with you. My last question would be, how do you keep healthy? How do you keep focused? What do you do?
Well, you know, as a lawyer, they tell you should always be arguing. As an arguer, you should always be analyzing. But if you want to live a long time, you should always be moving. So I try to get some exercise every day, even in these times. When I was younger, I used to have a reputation as being the cardiac addict. So I engaged in running marathons, doing triathlons, paddling canoes competitively. So I guess I still am a cardiac addict, but most of my cardiac activity is getting excited over a case.
Well, thank you very much, Patricia. It seems that we are running out of time, and I'm sure will be more possibilities to see each other in the future and see the audience. And thank you very much for your time. Thank you very much for being an inspiration for many of us and many students who went through the wonderful program with the Stockholm University. Thank you very much. Keep healthy and safe. And back over to you, Natalia. Thank you.
Thank
Well,
you.
I can only join your words, Roman. And at this point, we have come to the end of our webinar. I owe a special thank you to Ruslan Mirzaev, the founding partner of law firm Adrem, for his help in organizing this event. Ruslan was one of the driving forces of this conference. I ask the audience to please join me in thanking all our excellent speakers. Thank you everyone for participating. Stay safe and see you soon in real life.